Chapter 43. Carrying Concealed Weapons. Section 659. Carrying Concealed Weapons. The English Statute of 1328 making it a crime for anyone except the king or his servants to go armed, was held merely declaratory of the common law. Now the crime in this country is entirely governed by statutes, which usually prohibit the wearing of concealed weapons in public places. These statutes are constitutional. Under most of them the open wearing of weapons is not punishable, but the concealment even for a moment is within the statute. Nor does it matter how the weapon is hidden, concealment in a basket, satchel, or even wearing a pistol in a holster, being indictable. But it was held that carrying in one's hands saddlebags with the lid down, in which a pistol was hidden, was not indictable. It is enough that the weapon was worn in one's own house, if the statute makes no exception, and it does not matter that a gun was unloaded, or was carried for hunting, or was so defective that it could not be fired. But criminal intent may be negatived by showing that the weapon was being carried merely as property, to a repair shop, or to return it to its owner, or as merchandise for sale. Under most statutes the weapons must be worn in a public place, and under many, travelers are excepted from the penalty. To fall within this exception, one must be absent from home on an occasional business trip, and the exemption covers the period of such journey. Making a daily trip from one's house to his place of business, or a trip from the outlying townships to a county seat in the usual manner, is not travel. Where persons threatened with or apprehending personal danger are excepted, reasonable ground for apprehension must be shown. Officers in discharge of their duties are usually excepted, the exemption applying only when actually in discharge of official duty, and affording no protection when the officer is outside of his district.